Well, as we were talking about, this is the defense attorney, Mr. McKay, is still cross-examining Torres. He was the eyewitness to the actual shooting as he was driving north taking his son to the hospital. So I talked a little bit about Mr. McKay's delivery and the fact that it appears as if this witness is not excited about having to answer when he's being grilled by this attorney. I am so happy to introduce right now our special guest, Sanford Rubenstein, who is a civil rights attorney. Thank you for coming. Perfect to have you on with this story.
Thank you for having me.
So tell me, what is your thought about the fact that this is a bench trial versus a jury trial? Does that make a difference?
I think not only does it make a difference, I think that's probably going to be the most important decision that was made by attorneys in this case. Now, in federal court, prosecutors have to agree to waive a jury. In state courts in New York, for example, the prosecutor doesn't have to agree. It can be done one-sided by the defense lawyer, waive a jury, judge-only trial. That's a crucial decision that has to be made because a jury could be hung. You don't know what a jury is going to do. A judge, you don't know either, but a judge really doesn't look at the histrionics, doesn't look how lawyers cross-examine in terms of their mentality in cross-examining. A judge looks at very carefully, and this judge is a former prosecutor, and I think she understands as a former prosecutor the importance of police officers being truthful when they write reports. And if this, in fact, is an attempt to cover up, which is what this case is all about, I think these police officers who have been indicted for these crimes are in big trouble.
And I'll tell you what, so the judge we've talked about so far, the judge has been very engaged, and she has not really put up with the theatrics that a lot of attorneys engage in because of a jury. So do you think that she's going to be able to put all the theatrics aside and really apply the facts to the law to come up with the verdicts in this case?
Absolutely. More so than a jury. More, you know, while a jury is supposed to not think about the histrionics and only decide the case based on the evidence, the facts from the witness stand, a jury is influenced by other things as well. So the strategy here seems to be for the case that was already tried and there was a conviction to almost be retried in this case. That's what this case is. That is not what this case is all about. What this case is all about is the attempt to cover up. That's the allegation, or the cover-up. I don't think this judge is going to be influenced in any way, shape, or form by the histrionics of defense lawyers. This judge is going to decide this case based on the facts. And I'll tell you, this witness is a very important witness because this witness seems to be confirming what we've seen on the video, pictures of the truth. Now you have an eyewitness confirming that. These defendants are in big trouble.
All right, so stay with us. I'm so excited that Sanford is joining us. He has so much experience in this field. We're going to take a short break, but please come back as we resume live coverage of this trial. My guest here, Sanford Rubenstein, who has handled a number of civil rights cases involving cop shootings. So let me ask you, in your experience, tell us of all the ones you've covered, I think you said on a break about 20, what is your experience about cop shootings in general and what the verdicts are like, or even in civil cases, what the outcomes are?
Well, 3 of the cases that I was involved in representing victims civilly was the torture of Adnan Syed here in New York City. It's 20 years ago. The killing of Sean Bell, and also the killing of Eric Garner. Bottom line is, very difficult to get convictions in these cases.
All right.
Very difficult, especially with juries and also with judges. But when there are convictions, they are upheld in the appellate courts.
All right, we're going to return to some of that discussion, but first let's go back live again to the cross-examination of Torres. All right, we could hear an objection. I know they're going to resume with their questioning. We may go back to that trial live, but in the meantime, let me just ask our special guest, Sanford Rubenstein, Sanford Rubenstein, I apologize, I did that again. Just a quick question, and that is, talk to us about using prior testimony in written form to refresh the recollection of a witness.
It's important. But there's another issue here that's very relevant. This witness had to testify before 2 grand juries, already testified at 1 trial, and is now testifying at another trial. What defense attorneys want to do is find inconsistencies, to say if he's lying about that, he's lying about everything. I don't know if that's going to happen in this trial with this witness, because what they're trying to do, they may not be successful in doing, because the bottom line is, did he see what he said he saw? And what they're also trying to do is show that his perception of what he saw may not have been accurate. So far, I haven't seen them accomplish that during this trial. And again, we have pictures of the truth, the video, a very crucial piece of evidence in this case, and this witness seems to be confirming what we saw on the video. So to impeach him on a minor issue, that's not going to change this judge's view of whether he's truthful in his testimony.
And let me ask you this, Sanford, could it potentially change the view of a jury if this was a jury trial?
I think it would be more effective with regard to a jury determination, because remember, in a jury trial, one juror could say, I'm not going to find him guilty, even though all the other jurors agree there's guilt, and there'll be a hung jury. And that's one of the things defense lawyers look for when they can't get an acquittal, is a hung jury. So this decision early on in this case to go with a judge-only trial, I don't know if that was the right thing to do here. We'll see at the end.
All right, so I think we're going to resume court testimony now. Let's see if he's answering any questions. All right, I'm going to join my guest again here, Sanford Rubenstein. I'm so glad to have you. Here's one of my questions. So here's our understanding of Officer Walsh's position in this case. His defense, and that was his attorney that we heard for the viewers questioning this witness, his defense is that, number one, his reports were actually based on his recollection, and number two, that he saw and perceived things differently than the video showed. What's your response to that? What do you think of that defense?
Well, I think that's about the only way they can go. You have another police officer who's testifying in this case that what was reported in this police report was false. So how do you get around that? The only way to get around it is to say, well, my perception was different. But we have a video, we have a witness, an eyewitness. This is a tough defense.
All right, so do you think they're going to get a conviction in this case?
What's your... One thing I know from 40 years of practicing law in the courtroom, you never know what a jury is going to do. You never know what a judge is going to do. But so far, I would say leaning towards conviction.
All right, and that's why I love Law and Crime, because we cover these trials live and we get to see what the judge or jury does, in this case, the judge. So we're going to return to the courtroom. He is still being cross-examined by one of the defense attorneys. And again, this is Mr. Torres, who witnessed the crime from the car, and I shouldn't say crime. Well, Van Dyke's been convicted, so I guess I can. He witnessed the shooting of Laquan McDonald, and he then came forward to say there was no lunging. So let's now go ahead and return to the courtroom live. So after the cross-examination was completed by the three defense attorneys, the prosecution said we need to be able to look at the document that they were referring to on one of the defense cross-examinations. We need a short recess to do that. So the judge has granted that recess, and so we will rejoin that trial when they come back to trial. In the meantime, Sanford Rubenstein, who is a civil rights attorney who has experience in police shooting civil rights cases, is our special guest today. So let me ask you now, just tell us in general, how do you think this trial is going, first for the prosecution?
Well, so far I think it's going well for the prosecution. And we should also understand that the reason the prosecution is looking at these documents is they may want to rehabilitate this witness with regard to some of the answers he gave on cross.
All right. And so what about the defense? Do you think that any of the three defense attorneys and defendants stand a chance in this case?
Well, I think if there were a jury trial here, if there's a jury here, they may have made some inroads. But I don't think they did with this judge. The judge is going to look at the credibility of this eyewitness. What's the motivation for this eyewitness making up a story? There's no motivation for that. This eyewitness is testifying to what the eyewitness saw. And yes, when you testify 4 times under oath, there may be inconsistencies. But the fact of the matter is, there's no motivation for this witness to lie.
So this is what's been interesting to observe in this case, and a very good thing. This judge has been engaged. She's already reprimanded one of the defense attorneys to basically say, we don't need your theatrics. It's a judge, not a jury. You don't need to do that in this courtroom for this trial. We've also heard her reprimand the witness on the stand, Jose Torres, and say, I've told you 4 times you need to answer the questions. I can't tell you again, you've got to answer the questions that are asked. You guys cannot talk over each other, meaning the attorney as well as the witness. And so she's certainly running her courtroom, which is, as a judge, one of the jobs. The judge has to run the courtroom to make certain that all the laws are followed and the facts can then be applied by the judge to the law. So we are going to return to court at this time with testimony from Jose Torres, one of the eyewitnesses to the shooting. Right, you were just watching some of the recorded testimony from a little bit earlier today of the eyewitness, Jose Torres, who saw the shooting, and this is when Van Dyke shot Laquan McDonald, who was killed, and Van Dyke was convicted already of murder in the second degree, and now we have the trial of these 3 officers who allegedly conspired and covered up the shooting by Van Dyke. So it's really an interesting case to follow. Here's some breaking news I want to make sure that you understood from what the prosecution was requesting. It's fascinating from my perspective. The prosecution was saying that the defense never gave a copy of the internal police investigation statement by Torres, the witness, to the prosecution, so that the whole time they were utilizing that document to cross-examine Torres, the prosecutor didn't have a copy. They asked for a copy, they were given a copy, so they're now on a recess for a break in order for the prosecution to actually review that statement. So joining me, Sanford Rubenstein, let me ask you, why do you think, if you can, defense had not provided a copy of that report when they are actually going to use that to cross-examine the witness?
Well, we know the prosecution has an obligation to give any information to the defense which may help the defense, anything they have in their file. If not, that's prosecutorial misconduct. I don't know that works the other way. But the fact of the matter here is the issue involving this witness is clearly credibility. Is he being honest? That's the issue. So we have something else also called the blue wall of silence. Why was this not turned over to the prosecutor by the police?
That's an excellent question. So join us as we resume this trial. Right now, we're going to take a quick break, but please come back to Law and Crime. So we are still joined by our special guest, and we are going to talk a little bit more about this trial. Let's talk about the whole defense theory of adding to this case reasonable force, and whether or not Van Dyke, who's not a defendant in this case, has already been convicted for shooting Laquan McDonald. Why are they using witnesses in this case to talk about whether or not that defendant used reasonable force? What does that have to do with falsifying police reports and conspiracy to cover it up?
Absolutely nothing, except for the fact that they're trying to influence, in this case, this judge. If it was a jury, it would be much more significant with regard to the underlying case, in which there was a conviction already, but they're still trying to say that that conviction is something that was a mistake. He did use a reasonable amount of force. Has nothing to do with these charges, but it's trying to color the fact pattern and the facts of the case to get sympathy from the judge.
All right, so we're going to keep following this trial. They are on a break because the prosecution had to review documents, the witness's statement that he made when the Internal Affairs investigated this matter. And so while the prosecution's on a break reviewing those documents, we're going to return to some testimony earlier today. It was direct examination of Torres. And again, he was the eyewitness to the shooting as he was in a car and was stopped and saw the shooting. Let's return to that direct testimony.
Yeah, it was close.
In just a minute or two, we're going to be going back to court live. They're resuming court. But while they get set up in the courtroom, I want to ask another question of our special guest, Sanford Rubenstein. Let me ask you this. In all of this we talk about, you've got 3 police officers on trial. What is your opinion about the impression of police officers by the public and perception of them 20 years ago, say, versus today in today's climate?
Well, I think the real issue here is the credibility of police and how important that is to the public, that it's really important for police to be believed. And when you have a case being brought against police for lying in police reports, and you have another police officer, who I believe is the hero in this case, the female police officer, who came forward and said that report was not true, it attacks the credibility of police. And that's a problem in all criminal justice trials, because you want to be able to believe the police. But when there is a fact that is not truthfully reported in a report as an attempt to cover up the killing of an individual by a police officer, that's a real problem in our society, because what it goes to is the credibility of all police and all police reports. It's a real problem.
So one more quick question. The hero you referenced was Dora Fontaine, and she's the one that said the police report's wrong. There was no lunging. That didn't happen. So when she said that, do you know, they say, she says that she was called a snitch, for instance. Does that surprise you at all that the other police officers are giving her grief?
Doesn't surprise me, because once again, the blue wall of silence is the phrase used to describe this type of behavior. And she has to go back, if she goes back in the field and need other police officers to back her up. And will they back her up the way they would have backed her up before this happened, before she testified against police officers? So I think she's the real hero in this case.
All right. So is there any, when we talk about the public perception of police, has there been any change that you're aware of in terms of how police investigate cases and conduct their investigations that may or may not play into that?
Well, I'll tell you the change that is not good. This Attorney General's office, Sessions, stopped doing pattern and practice investigations of police departments all over the country. In the Obama administration, we had 20 police departments who entered into consent decrees with prosecutors to do change, improve training, whatever had to be done to stop police brutality. That's gone now. This Justice Department isn't doing any of that. And I think that that is not good.
All right. Thank you for all your thoughts on this case. Now, we are going to go back to the trial live, resuming testimony, and I believe that this will be the prosecutor having redirect of the witness Torres.
Regarding schedule.
That was the end of Mr. Torres, who was the eyewitness to the shooting. His testimony is completed. We'll wait and see what witness they're calling next. So let's again talk about what the defense can argue in this case. I'm going to join my special guest. Sanford is still here with us. Thank you for being here still. And so when we talk about the defense's case and what they're going to present, talk again first about why do you think they chose a judge over a jury? What's the benefit to them?
Well, there was a conviction in the underlying case, so that might have played a role in them deciding to go judge only. But I don't know that that's going to be a wise decision when we get the end result in this trial.
All right, so it's going to be really interesting to see how this goes with any additional witnesses that they do call. So let's talk also about the fact they have 3 different defense attorneys and 3 different defenses. Does it surprise you that each of the defendants is doing a different type of defense?
We call that 3 bites at the apple. Obviously, they're working together, these 3 defense lawyers, and each one is taking what they believe to be a course to try to get an acquittal. The importance here of the witness being as truthful as possible and the judge believing the witness and his credibility is paramount in this case. Between that and the video, again, pictures of the truth, I think there is substantial evidence here of a cover-up.
All right, so we're going to return to the courtroom. I think. All right, so we still have Mr. Torres on the stand testifying. Now, this is a replay. So he has testified for most of the early afternoon and late morning in this case. And remember, he is the individual, he was just going to take his son to the hospital, and on his way, he saw police activity, he stopped, he witnessed the shooting. And so it's testimony that's really important because it's an eyewitness account based on his perceptions, what he recalls of what happened when he was shot, he being Laquan McDonald, by Van Dyke. Van Dyke has been convicted of second-degree murder in this case and is currently serving that sentence. And then we have these 3 defendants who allegedly, as Chicago police officers, conspired and covered up the crime. So we're going to return to some of the testimony of Jose Torres in this case. So testimony from one of the defendant's partners who was at the scene when Laquan McDonald was first encountered. Again, there had been testimony that he had slashed a tire on the police car, gone after a windshield. So let me bring in our second special guest today, Kendall Coffey, former U.S. attorney. So happy that you're here with us and joining us. Let me ask you this question, the testimony we were just listening to. So he testified that he encountered McDonald and said, drop the knife more than once, repeatedly. What does that have to do with these charges of conspiracy to cover up a crime and falsifying police reports? What's the relevance?
Well, not much. I think from the standpoint of the defendant officers, they think there's a value in a narrative that says that the victim simply was ignoring their instructions and was a danger perhaps to the public. But the problem really is that even if somebody is acting illegally or unresponsibly, officers don't have the right to execute the person on the scene of the crime, which was, of course, the charges in effect that the jury convicted Officer Van Dyke of. And when you get to false, obstructive conduct, false police reports, trying to do a cover-up, what happened earlier has very little directly to do with that. Now, maybe in a jury trial, some of this would have more value. That is to say, the jurors would say, gosh, maybe the officers really had a right to be upset, worried, confused about what McDonald was doing. But you've got a bench trial. And so I think things that have marginal relevance don't do much good when it's just a judge and you've got an audience of one.
All right, so this is an amazing trial to really dissect because there's so many different moving pieces and aspects to it. We are going to take a short break, but please come back as we continue to watch testimony and analyze this trial. Basis of the prosecution's argument in this case, and when they've appealed this case, they are saying, in effect, that there was an alibi witness that was not presented. That's the defense's argument. The prosecution is saying, listen, even if that alibi witness was allowed, they are going to say that he was in the library, which is an inconsistent statement, and so it shouldn't be allowed. And in every case in which an alibi witness is not presented, it should not be allowed that the conviction's overturned and it's sent back. So let's join our guests again. Let me ask you, Sanford, what's your opinion of this alibi witness not having been called as grounds for this case to be retried?
I think for a defense lawyer, not to call an alibi witness on a case like this is clearly ineffective counsel. And if ineffective counsel has been determined by a trial judge, I don't see this appellate court overturning that. I think this defendant is going to get a new trial.
All right, let me ask you, Kendall Coffey is our former prosecutor, U.S. prosecutor who's with us. Do you have the same opinion? And does it make a difference? The judge even said, but wait, what about the fact that this attorney for the defendant never even contacted or talked to the alibi witness?
Well, I think that's a critical issue because you've got an alibi witness. We all know alibi witnesses can help a defense, especially if you don't have overwhelming evidence of guilt. And don't you have to at least check out the story, make the call, and then if you make a reasoned judgment, this alibi witness isn't going to do anything for us, could even do more harm than good, fine. But to completely shut your eyes to a possibility that could make a difference in a somewhat close case where there's a possibility of arguing reasonable doubt, I agree. That sounds like ineffective assistance of counsel to me.
All right, we're going to go back to hear more of the prosecution's argument. And after that, join me with our guest to talk about how Serial, the podcast about this case, may or may not have affected where we are today. All right, so we're going to return now to our special guest. And here's one of the things that they're raising. The prosecution is saying, listen, the defense is asking for a per se rule. What does that mean? Let me ask you first, Kendall, what does that mean? What's that distinction for our viewers?
Well, what they're saying is rather than case by case where the trial judge would look at all the circumstances and consider whether in this case it was so significant that a new trial is granted, that any time a defense lawyer fails to investigate or undertake some inquiry about a potential alibi witness, that establishes ineffective assistance of counsel. So not just depending on the circumstances, but each time, every time, it constitutes ineffective assistance of counsel would be the per se rule.
All right, so let me ask you, Sanford, why shouldn't that be a per se rule? Do you think it should be?
That totally should not be a per se rule because each case has to stand on its own facts, and every case is different.
Okay, thank you so much. We're going to take a short break and come back. We'll be back in just a few moments. Adnan Syed, if the name's familiar to you, it may be from the Serial podcast that he was the subject of. So I'd like Sanford Rubenstein, our civil rights attorney, to join us again and talk about court of public opinion. Does it make any difference as to where we are today with this appeal because of a podcast that was wildly popular?
It's not supposed to, but it does. The fact of the matter is, in addition to a courtroom and a court, there also is the court of public opinion. And when there is a public issue raised that the public has an interest in, certainly that's something that's known by the fact finders, in this case an appellate court. So I think it does make a difference, at least in bringing in the issue before whoever it has to be brought. So the court of law and the court of public opinion, They both exist.
All right. And so one of the defense attorneys has been quoted as sharing and saying that absolutely they don't think that they would have gotten as far as they have in this process and with the appeal, but for the Serial podcast. Would you agree with that statement?
Well, I think that it certainly has an effect. It's not supposed to, but it certainly does have an effect. And I think when public opinion is there, that's something that is listened to by the powers that be, so to speak. I think in this case, they're going to give him the retrial.
All right. So just real quickly, what's your gut? Do you think if they give him a retrial, do you think that the prosecution's going to take it any further or let it go and retry the case?
There's going to be a retrial. I don't think they would have appealed the decision of the judge if there wasn't going to be. There's going to be a retrial. Let all the facts come out and a jury or a judge make the determination of guilt or innocence.
All right. Sanford Rubenstein, thank you so much for joining us, and I'm very happy that Kendall Coffey, former U.S. Attorney, is going to remain as your guest. Unfortunately, I'm going to be signing off as the host, but you have a fabulous afternoon planned, and so I hope that you will stay with us. We will be returning live to the Illinois trial, and we will hear what happens in that conspiracy theory trial against cops.